Good afternoon. Thank you to those who have joined us already. We're just going to give it a few moments while we wait for everyone to join us before getting started. Afternoon, Alyssa. Afternoon, Asafta. How are you both doing?
Hi, James.
Doing well, thank you.
Doing
Good
well?
to see you.
Yeah.
Yes, thank you.
Excellent.
Okay.
Always nice to see Alyssa and Asafta. We do a lot of these things both in person and online, so it's nice for us to catch up as much as it is.
Definitely, yes.
And the funniest thing, Safta and I were saying the other day, we get on so well when we do these things. We've never actually met in real life.
That's right.
Have you not?
That's right.
No.
Very odd, isn't it? Yeah.
But I feel like we're old friends.
Absolutely, absolutely, and that's what it should be.
Yeah.
Absolutely.
We'll make it happen one day.
Well, yeah.
Yes.
Yeah, definitely.
Right, I think we'll get started. Everyone should probably be in by now. So welcome, everyone. Welcome to LAW2023 Online Family Law Shape the Debate, sponsored by Our Family Wizard with me, James Evans, Safta Mahmood, and Alyssa DaCosta-Waldman. In this live session, you can put your questions to Alyssa and Safta and interact as the information is being delivered. Today's live Q&A is due to last 1 hour, and we'll cover your pre-submitted and live questions. To the right-hand side, there is a chat function. All questions are submitted in private, so please ask away. And if you're watching a replay, the live chat function is disabled, but you may contact the solicitors group for further information. A recording of today's live session will also be sent out by email within the next few days, so please do keep an eye out on this. Time to introduce ourselves. As I said, my name is James Evans. I'm the head of UK professional education at Our Family Wizard. I previously worked as a teacher before joining the family law world about 4.5 years ago, and my role consists of introducing Our Family Wizard to family law practitioners all across the country. Our Family Wizard, we work with courts, chambers, firms, barristers, CAFCAS, mediators, organisations, charities, anyone who's helping parents do divorce and separation. I am a member of the East Sussex Resolution Committee, the Family Dispute Solutions Group with Alyssa, the Family Law Language Project, the Parents Promise Alliance, and the Family Mediation Week Committee, as well as I'm being the chair of the Support Through Courts Family Ambassadors Board. I was recently shortlisted for the Innovation Award in Mediation in 2021 and 2022, as well as being shortlisted for Resolution's Innovation Champion Award. And we've also been shortlisted for the Family Law Innovation of the Year at the National Family Law Awards as well, which is all very exciting indeed. Safta Mahmood. Safta has extensive experience in both practicing and teaching family and children law for over 27 years. Safta practices predominantly in children law proceedings alongside his lecturing and legal writing. He has been a continuous member of the Law Society Children Law Accredited Scheme for approximately 20 years and is both an assessor and an author, having written in various legal publications, including for the Law Society. He is a highly articulate and popular speaker who has a practical and pragmatic approach to his subject. As part of LAW2023 Online, Safta's sessions include Divorce, Dissolution, Nullity and Judicial Separation, What Are the Differences? 2023, and The Use of Prenuptial Agreements and Conduct Issues in Financial Remedy Matters, 2023. Alyssa DaCosta-Waldman. Alyssa is a practicing barrister at New Court Chambers in London. She specialises in financial remedy cases and is also an expert in cohabitation claims. She is a regular speaker on legal topics and an author. During her career, Alyssa has contributed to Blackstone Civil Practice, co-authored Family and Matrimonial Law in Cavendish, solely authored Everything You Wanted to Know About Practicing Family Law in Cavendish in 2004, and last year contributed the chapter on Trust Law in Resolution's Cohabitation book. Alyssa encourages and practices non-court dispute resolution methods as an experienced mediator, collaborative lawyer, and family law arbitrator in finance. As part of LAW2023 Online, Alyssa's sessions include Do We Still Need to Prove Detriment in Talata Cases, 2023, and What's New in Schedule 1 Children Acts, 1989 Cases, 2023. So to kick things off, we're going to start with some of the questions that you have sent in. Just to remind you, if you do have questions as we go, pop them in the chat. We'll ask them as they come, and we will make sure that Alyssa and Safta get to them. The first question that we have here, and again, this is for both of you, I suppose, whoever you think can contribute best here. So the question is it possible to summarise the powers of the court and factors of a court that will have regard to in considering the division of equity in cases where a property is in joint names and there is no other evidence in the conveyancing documents re the equitable shares?
I'm going to have a go at this one. And I know Safta and I both lecture extensively on Talata. So the simple answer to this question is no. And the reason is the way the question is framed, it's almost, and this no offence or criticism is intended, but this is a regular question from family law practitioners who would like to think that a talata claim between unmarried people is exactly the same as a matrimonial financial remedy application. It is not. And the reason is this. In matrimonial cases, we look forward. We look forward at providing a fair outcome for married people whose relationship has come to an end, and we need to divide their assets. And in that case, we look at all their assets, pensions, income, all sorts of stuff, including the family home. And when we're dealing with matrimonial clients, we have the benefit of a statute, the Matrimonial Causes Act, Section 25, which guides us and which guides the courts. And I hesitate for a moment because most of you will probably be aware that that is under significant review at the moment. And many judges have said, as many practitioners have said over many years, most recently, that it's incredibly difficult to advise in financial remedy cases because the only thing you can predict is the unpredictability of the outcome because of the breadth of the discretion, even with the guidance. Now, going back to the initial question, with unmarried parties, somebody makes an application under talata. The court's powers are very limited because the court is not dealing with a whole range of assets that the parties may have. The talata court is essentially dealing with real property, usually the family home. And on that basis, we have to go to that statute. So the application, the claim is made under Section 14. The factors the court considers in a talata claim are under Section 15. None of them carries any greater weight than the other, and they include, but in no particular order, whether minor children live in that property. That does not, it's not the same as Section 25 MCA, where the children would be the first consideration. It's just another factor. Are there any other beneficiaries of the trust? Is there a mortgagee? And stuff like that. There are 4 factors, but, very limited. And the court's powers are limited because under talata, the court can make declarations as to ownership. The court can order a sale or postpone a sale. That's it. The court cannot, as I've often seen people seeking, transfer property as you can do in the matrimonial jurisdiction. There is a case called Begum and Hafitz where if the parties agree, you can have a recital that one party may be a preferred bidder on a buyout, but only by consent. So very limited powers. So I've summarised them. That's it. And the other thing is, I'm just looking at the question, in cases where a property is in joint names. Well, that's another thing, because what the first step you want to take is to look at your TR1, if it's in joint names, is a box ticked as to, is it beneficial joint tenants? Is it tenants in common in equal shares? Is it tenants in common in different shares? Because that will all affect what the outcome may be when the property is sold and the net sale proceeds are distributed.
That's brilliant, Alyssa. Thank you for that. That's really, really helpful. And hopefully that does answer the question. Can I just take that slightly further, if I may, just as a kind of ancillary question? And I suppose what we sometimes have is, going back to the old conveyances, talking about before we had the revised TR1s, people buying in the 1960s, 70s, for example, where, they may have bought a house, it's put in joint names, they didn't declare the respective beneficial interest. So you got the old conveyance. And now 2023, the 2 of them have fallen out. We know that the house is in joint names, but because there was no declaration of trust created at that stage, that's where we sometimes have these problems, don't we? Because that's where stack and dowd and the line of cases comes into play. So presumably, would you agree that in those type of situations, is that where we would be saying, well, actually, the judge is going to be looking at the whole course of dealings to see how they've lived their life for the last, 40 years or so in deciding what that beneficial interest should be, if you're looking to vary it,
Well, I've got a couple of things to say about that. Firstly, I think the cases, because what you're talking about is the pre-1998 transfer document, the old Form 19, which was precisely the reason Stack and Dowden ended up in
shows my age. That's right.
And mine, because I remember those. It is increasingly rare to see cases based on the old Form 19 because that went out in 1998, which is 26 years ago-ish, something like that. Can't do my maths quickly enough. So that's the first thing. And can't remember what your second point was.
And I suppose if one of them is then saying, well, actually, I want the beneficial interest to be varied, so it's not going to be presumption of 50-50, would the court then do a survey of the course of dealings? Is that where
possibly
Stack and Dowden?
The initial point, isn't it, is Stack and Dowden, equity follows the law. So if it's in joint names, there is a presumption. There is a presumption that it's 50-50.
Yeah.
And as we know from Stack and Dowden, parties should exercise caution if they want to a different outcome. So there's got to be a lot of evidence. And I think one of the difficulties is if you're dealing with a case where the purchase was that long ago, there's not going to be any conveyancing file. There's hardly going to be any evidence of their intentions. It's all down to whatever they say in their witness statements. If they go to a trial, whose evidence is going to be preferred, who's going to perform better on the day. And the risks on costs of those arguments I mean, my recommendation in most of these cases, because of the unpredictability of courts and the perversity, dare I say it, of some of our lovely judges, is to recommend that people go to mediation and not your resolution, sort of lots of little meetings, but a one-day commercial style mediation where everybody is trial ready. Or the other thing that I think is particularly useful with these sorts of cases is the civil version of an FDR, neutral evaluation, which is in fact recommended in the Chancery Guide. Yeah,
absolutely. And I think a lot of people forget about that, don't they? Because, you know, many practitioners, a lot of, you know, yourselves who've logged in today, you know, you'll be family practitioners, so to speak. And Talata is something that many family practitioners do shy away from because of the, you know, heavy emphasis on civil. But actually, there's a lot of similarities, isn't there? You know, the kind of FDR type meetings and hearings you can have in Talata cases.
Something different. We don't call it an FDR, but you can have a similar style of hearing. Or you could go privately to do that to retired judge or senior counsel. And it's worthwhile because most people don't want the risk on costs. They don't want, and it's good to have an early neutral evaluation to get an indication of who's more on the side of right, if you like.
Absolutely, particularly when we look at the fees for pursuing a Part 7 claim. You know, looking at the fee for that versus, you know, what we would be paying for a financial remedy application, it's miles apart, isn't it? So clearly it's a factor.
Yeah, absolutely.
That's incredibly helpful. Thank you both. And the person who's asked that question has messaged to say thank you that was their question. And to review, is the transfer deed, is what they've said. But as the conclusion is, has the court the power to adjust division of equity if registered as joint tenants, or T&C with no specific division referred to or other than 50-50?
Well, if you've got a TR1, that document, as we know from Goodman and Gallant, and following that Pankania and Chandegra, which came somewhat later because following Stack and Dowden, everybody was challenging that even where the box was ticked. We know that the TR1 with a box ticked is conclusive. Absolutely conclusive. The court cannot move away from that. That's the end of it. So, you know, no, the court cannot vary because it's for if there is a declaration of trust, it is for the parties to vary it in writing.
Absolutely. And only in the absence of fraud and undue, fraud or mistake, I suppose, if a land registry have made a mistake, only in those exceptional circumstances, but short of that, absolutely. It's there, isn't it? You're stuck with it.
And trying to prove fraud is, I mean, that's in a civil court, that's a really high bar.
Yeah.
Yeah.
Excellent. Thank you so much. I'm sure the person who's asked that is very grateful indeed. Please do continue to pop your questions, and we've had another one come through. They've outlined their case in quite a lot of detail, so I'm not going to go through it all just for the sake of time. But I'll try and summarize. So the parties are not married. The client owns the property. They've left the home due to domestic abuse. A non-molestation occupation order has been put in place. They've now left the property, put in a Talata claim. A substantial amount of money has been gifted as a deposit, and the judge has addressed the factual matters of this, including the deposit, and found that the partner deposit was a present. So in the Talata matter, the claimant is presenting the same argument that has already been considered and decided upon the family court. Can they then use the judgment from the family matter to support the client's case to defend the Talata matter?
That's a long question.
Yes.
You can see the details there.
I would say yes.
Yeah, I mean, simple answer is yes. But of course, remember, to the person who's asked that question, bear in mind, obviously, the family proceedings are a just different jurisdiction to a Talata, that's civil. So obviously, if you're going to try and use it, you need permission. So don't just, get it and stick it in the bundle, because you'll be breaching the family procedure rules, and, you'll be doing full contempt. So do it the proper way, get permission. You've got to justify necessity. And then, yes, any of those findings that are made, which are going to be of assistance in the civil case, can then be used if needs be. Yeah. So do it the proper way.
And what you would, yes, that's absolutely right, Safta. But what you wouldn't want is, you wouldn't want the potential, I'm not sure who's claimant or defendant, but the person who's made the gift and been found to have made a gift in one lot of proceedings, then to deny it in the second set of proceedings. And that's why that judgment in the other proceedings is absolutely crucial.
Super.
Excellent.
Thank you. That's very helpful, I'm sure. We've had another live question come through. Thank you to those posting those live questions. Keep them coming. The question is this: if the property is owned, I don't think this is in relation to the previous case we were discussing. If the property is owned as a joint tenant with a declaration of trust in equal shares, the parties remortgaged for an extra 80,000 and then separated. The man took 40, the lady used 40 on renovations in the home, which was what the money was earmarked for. Are we then stuck with 50-50, even though the man has an extra 40k?
I'm not sure I can get my head around all of that.
Okay.
What I'm not clear is, you said something about the 50-50.
So the parties have remortgaged for an extra 80 and then separated.
Right, but go back. You said something about 50-50 before.
Yes, so the man took 40, the lady used 40 on renovations. Are they then stuck with 50-50, even though the man has an extra 40,000?
Well, has he got an extra 40? They're both still liable for that lump of mortgage, aren't they? They're jointly and severally liable. He's got his 40,000. She's used hers in the property. She might want some kind of recompense because she's used it in a way that enhances the value of the property, for which he's going to benefit as well. Whereas she's not necessarily...
That's what that money was earmarked for.
Yes, and she's not necessarily benefiting from the 40k that he's gone and used elsewhere.
I think so, yeah.
So I think there'd be a bit of equitable accounting there.
Yeah. Do one thing with that? Doesn't the question say at the beginning? Doesn't it say if the property is owned as joint tenants with a declaration of trust in equal shares? So if you got a declaration,
what I was looking at. It's not clear whether they're beneficial joint tenants, therefore ticking the first box, or whether they've ticked the second box and they're tenants in common in equal shares.
Yeah,
because that puts a different slant on it. Because if they are tenants in common in equal shares, and she's used her share one way and he's used his another, but again, you would argue, wouldn't you, that even though she's improved the entire property, that includes his half. If it's a tenancy in common.
Yeah, so and absolutely, and that's where your
equitable accounting.
Absolutely, that's where equitable accounting comes in. But of course, with equitable accounting, the person who may have, assuming the one of them's moved out, for example, then you find the argument of occupation rent is then thrown the other way to rebalance it sometimes.
Yeah, interesting.
So one kind of
a case where one person's living in the property, the other one joined in the purchase in the background, is not on the documents of title,
right,
has been in receipt of some of the rental income, and is claiming she never intended to live in it, and she's claiming occupation rent. And it's really interesting because if you go back and look at, I think it's paragraph 93 of Stack and Dowden, it is abundantly clear that occupation rent is only payable if you were supposed to be in occupation and you're not.
Exactly. And I think that's right. So it's a bit like there's been a few of those cases where, say, there was that Davidson Johnson case, the one where husband.
That's a long while ago, isn't it?
Yeah, where husband becomes bankrupt, a trustee in bankruptcy comes on board and says, right, we want more than half, and they try and argue occupation rent. And the judge said to the trustee, the judge said, hang on a minute, were you going to live in the house with the wife?
Exactly. The trustee in bankruptcy, I don't know if the wife fancied him, but she was never going to live with him. So.
Absolutely. That's fantastic.
Exactly.
The good news is this has really sparked a lot of interest to those listening.
Oh, really? Oh, my gosh.
Quite a few follow-up questions. So this is good.
I tell you, James, I think this indicates how difficult, and this is no reflection on family practitioners, but if you are a regular family practitioner with your matrimonial causes hat on or your children act hat on all the time, TOLATA represents quite a challenge because of its being in the civil jurisdiction, and it's very narrow, only relating to the property and various things around the family home or other homes or investment property. And it really does have to make us think differently.
Absolutely. And one of them, I'm going to try and group some of these questions together. There seems to be a little bit of confusion around the whether it's joint tenants and what the difference is with tenants in common. So would you have a declaration of trust if joint tenants?
Yes. What? Okay. Right. Your TR1.
You're thinking you only use declarations.
No. People need to understand, and I'd love to be able to share my screen, but that will take us forever, and I can't do that. We've got all these lovely diagrams and pictures and whatever.
Yeah.
Right. Everybody who's online now, when we come off, go and look at a TR1 form. There is a box, usually I think on page 2. The heading of that box is Declaration of Trust. People do not need to create or pay solicitors to draft a separate declaration of trust. It's in the form. And there are 3 boxes. The first option is beneficial joint tenants. That means they each own the whole of the property. The second box, which is not a legal concept, but an equitable one, tenants in common in equal shares, which means you physically own half a house. The difference also between being beneficial joint tenants and tenants in common is something that sounds like a really exotic summer drink from Starbucks, the jus accrescendi. That is Latin for the right of survivorship. So if you are beneficial joint tenants, what that means is, in the event one of them dies, the survivor automatically inherits the whole of the property. It's outside of the estate, if you like, right? With a tenancy in common in equal shares, each party has the ability to bequeath their share to whomever they may wish. And that's relevant to people, mature people perhaps, who've got children from previous relationships, who want to ensure that if they purchased a house together, that they have half that they can each leave to their respective families. And then the third option in the declaration of trust, big box, the third little box, is tenancy in common in other shares which you have to specify. And the reason for doing that, and it might be advisable to have behind that a more detailed declaration of trust with some explanation, is where I would advise parties who are putting in unequal shares, you know, they're contributing to the property unequally, then it's relevant to work out what your percentages are in the purchase price and the cost of purchase and all of that, because that percentage will stay till the end, till, you know, somebody dies or the relationship breaks down and the property increases in value, but the percentage is the same. In the event, following all of that, for whatever reason, somebody wins the lottery, wants to put in a new kitchen or whatever, those shares, certainly in the two, options 2 and 3, can be varied, but it has to be done in writing. Safta, anything I've said?
Yeah, no, fantastic, really good, and really just to say, because I think a lot of people do get confused, I've found, where they think, you know, the TR1 itself is just a document which is used to do the transfer, but actually it's more than that. Like you say, you know, it's actually got those provisions on there. And I know sometimes solicitors will recommend to say, look, you might want to do a more detailed declaration of trust, and that's where, as you said, you know, you've got Goodman Gallant, Pankani and Chandagra, and, you know, those cases make it very, very clear. If you've got a declaration of trust which specifies, you know, what each of them are going to get, in the absence of mistake and fraud, that is binding. You know, there's no way around that. There is another form. I mean, I'm not a conveyancer, but there's another form. The JO, I was going to say, the JO is another one that I've come across. And
nobody uses it.
Nobody seems to use it. And I'm just thinking it's so helpful. You know,
for our watchers, our viewers, a JO is a form. It's called JO because that's for joint ownership.
Absolutely.
And one of the reasons that was brought in was precisely these problems, because often in the flurry of activity of completing the sale and purchase of a property, the TR1 doesn't get signed, or it's signed by the vendors, not the purchasers, one of whom is going to be your client in the Talata case, and all of this. So there is a JO form. And I think, you know, the people who ought to be watching this today, it's the conveyancing.
Well, good. There's good news. We have a conveyancer watching.
Good.
And they've messaged in 10 years plus conveyancer. They say that the TR1s are not available to download, and that the problem is that after 6 years, which is when the solicitors usually destroy the files, if the parties don't have a copy, all they have is a Form A restriction on the title if box 2 or 3 is ticked. Is that right?
Well, I disagree with that. Different firms of solicitors destroy their conveyancing files at different times. I had some that keep them for 12 years or 10 years, not just 6 years. I think the requirement is to keep them for at least for a maximum of 6, but some firms keep them longer. I wasn't aware of what's being said about the TR1, but I take that on board. But for me, that makes it even more essential that those conveyancers should use a JO, the form JO. Because if that is the case, that the TR1 is not accessible when there is a subsequent dispute, there should be a JO when people are buying and selling property.
Absolutely. And really just, you know, going further with that, sometimes, you know, there's been cases where, say, I don't know, you got man and lady, they want to buy together, they go to a building society, her credit rating's not as good as his, the building society are only going to release the funds to him exclusively, and they are saying the house has to be purchased just in his name. So they go to the conveyancer, both of them together. He's going to be their client, but she's obviously there with them. And that's where sometimes you may find that the conveyancer might actually do a note on their attendance note to say they both came together. The hope was to put in joint names, but, you know, credit rating couldn't do that. And hence it's been, you know, bought just in his sole name. Those attendance notes, if you can get your hands on them, and I appreciate, you know, some firms would destroy their files, but if you can get your hands on that as part of your pre-action disclosure, it's so helpful, because it evidences intention, which, as you know, what Talata is all about. It's about intention and detriment.
What I would say is, sadly, conveyancers, bless them, are not like other lawyers who, you know, the minute we talk to someone, there's a note. solicitors tend
right.
not to do that, and you'll find, you know, a little scribbled note, somebody's phoned in, and that's about it. But I think, again, and here's an idea, I think maybe try and get some conveyancers to more of these courses, because there are problems later on if the conveyancing process has not explained everything. And I've had numerous cases where the different types of ownership, the beneficial joint tenancy, the tenancy in common, it's not explained. Where if you've got cohabitants who are purchasing together or trying to purchase together, wouldn't it be appropriate to send one of them off to get some independent legal advice? That doesn't seem to happen.
Yeah, that's right. Because in those kind of cases, what sometimes happens is it'll be done almost on an execution basis, which is, here you are, the two of you are sitting in front of me. We've done a little sheet which explains as not, it doesn't explain it as well as how you did explain it, Alyssa, so eloquently. You know, it doesn't explain it that way, but it explains in a joint tenancy and tenancy in common, and then they're told, right, go away, think about it, and then let us know which one you want to do.
And they're not told about the pitfalls.
Yeah.
You know, if your relationship comes to an end, it's not like a divorce. This is what can happen.
Yeah, that's right.
Our conveyancer says, firstly, that it's only accessible if the first transfer, if it is the first transfer, such as a new build. But also in training, they're told to get disclaimers signed if they purchase in unequal shares.
Oh, that's good.
The family lawyers were advising them to sue their conveyancer.
Indeed. Yes, we do. Sorry, but we do. Because unless you can demonstrate that the conveyancer has given proper advice, if your client loses a Talata claim, then they're going to go after the conveyancer. So, you know, even more reason for conveyancers to have a checklist if there are unmarried parties that come to see them to purchase the property.
Absolutely.
Yeah.
Well, from the two questions for the half of the session that we've had to answer the two questions, I think we've gone to an enormous detail. And thank you, which is exceptionally helpful. And thank you to those who've come in with the live questions as part of this conversation. And please do continue to do so. We do have one other live question that's come in before we hit, if we have time to get our pre-submitted questions. And this is ever so slightly different, so that's why I've saved it to the end. So this person's outlined another situation. So with an unmarried couple who separate and the family home is owned by the male only, is owned by the male only, but the female is living there. Can she do anything to protect herself to stay there as the male is demanding her to leave, or will she have to move out? There is a child, but social services were involved and told the father to take the child, so the female is living in the family home whilst it is owned by the male.
I would think that's a Family Law Act question, you know, the occupation order. And whether there are reasons for her to have an occupation order. The way you said it was, he's got the child or she's got the child?
And the child, there is a child, with social services were involved and told the father to take the child, so the female is living at the family home.
Well, social services have told him to take the child. It sounds to me that there might be some issues with the mother. And therefore, the father might want to get some sort of occupation order to get back in with the child to live in the family home. That's what it sounds like to me. There is also the possibility of an injunction under Talata itself, but it's not the same. It's not the same as the Family Law Act's injunctions. No. So I think we'd need to know a lot more factually about that scenario.
Absolutely, and really, I mean, the kind of warning signs for me would be the fact children's services, social services are involved. I think there needs to be liaison with them, because of course, you know, there will be no doubt safeguarding issues there, and therefore a lot of what happens will be dictated by what the expectations are there. But as Alyssa said, you know, Family Law Act, occupation orders, non-moles, all of those things kind of come to mind. But I think you got your children's services first and foremost. That needs to come on board. Interestingly, you know, you mentioned, Alyssa, injunctions under Talata. Were you thinking of where, I don't know, you've got the lady who comes to us and says, you know, I'm at my mum's, I was living with him, the house is in his name, I'm thinking about a claim for beneficial interest, but I've just seen a for sale sign, I've rang the estate agents and they're saying, yeah, we're exchanging contracts later on this week. Is
yes,
that where you
would do? Is she? I
Yeah.
mean, if it's a family home, you can, you've got family home rights, haven't you?
Yeah.
Deal with that.
But if they're unmarried and we're cohabiting, this is the problem we get, because
can you not do an RX1?
Well, that's it. That's it. That's right. The RX1 or UN one. But I found with some land registries, they're really difficult.
They're very difficult. And the other thing that the land registry will do, if you make so an RX1, everyone, is a restriction. It's not matrimonial home rights. It's the other one. But the land registries are notoriously difficult, and they'll do it. But then they want you to go to an adjudication.
Yeah.
Don't they? And my view is that you are far better off, your clients are far better off with court proceedings rather than the land registry adjudication, which is far narrower, I think, in its focus than court proceedings where they're looking at the whole course of dealings between the parties.
Yeah.
Back to where we started.
That's right. That's right.
Well, thank you. The person who asked that question has said thank you. That's very helpful. So
great. Okay. I know. I just want to say there's so many questions today.
Yes.
There is a lot, isn't there?
And I'm sorry that we won't be able to get to all of them or answer all of them or in the detail that you want, but we are doing our best.
Absolutely.
I think it's useful to answer these questions that are coming in live, because these are the questions that are right at the forefront of people's minds off the back of what the conversation has had. So it is helpful. Yeah. I was optimistic perhaps that we'd finished with the Talata conversation, but someone has asked, in reference to that scenario you outlined after, where one party has poor credit, can you use the JO respectively?
Retrospectively.
To be honest, I don't know because I'm not a conveyancer. I don't know whether the land registry will accept it. So I don't know. I would have thought you probably can't. I would have thought you need to do it at the point of the transaction. Yeah. But to be honest, I do have to, I think, defer to our conveyancing colleagues on that, just to be absolutely certain on that. But yeah, my view, I would say, is probably not.
Yeah, I agree with Safta, because the whole point of the JO is to set out the beneficial interests at the point of purchase. And the party's contractual relationship with any lender has nothing to do with their relationship together and how they choose to own the property. They are two separate things.
Brilliant. Thank you. And there was one other request for clarification. Just finally, can we please clarify if equitable rules can override the TR1?
It depends what the TR1 says.
Okay.
The TR1, where one of the boxes is ticked as to the beneficial ownership under the section that's headed Declaration of Trust, and it is signed and properly witnessed, provided there is no issue with the validity of the TR1, unless there is fraud or mistake, then that document of title is conclusive as to ownership.
Great.
That's the answer.
Hopefully that clarifies that for that person. Thank you. Yeah. Thank you. Our conveyancer has said to sever tenancy is you need to apply for a Form A.
Sorry, what Form A are we talking about?
And if you need to enter into a separate declaration of trust, you apply for a restriction using an RX1.
Right.
That's from our conveyancer.
No. I'm a bit confused, and I hope that this person doesn't think that merely making an application for a financial remedy severs a joint tenancy, because it doesn't. There is some very old case law where it was questioned whether filing a divorce petition severed a joint tenancy automatically. It does not. There are various ways in which a tenancy can be severed. You can partition the property. Very old-fashioned, that doesn't happen. Generally, you serve a notice. You don't necessarily have to do it in a specific form, provided the notice says what you want it to say in relation to severance. And as I've already said, applying for a restriction, the restriction is merely to give notice to a prospective purchaser where the property is in the sole name of one of the parties, and the non-owning party wants to make a claim for a share.
Hmm.
That is not a separate declaration of
I
trust.
think they were referencing the JO form in terms
No,
of
the JO form is it's really a sort of add-on to the TR1 because of all the stuff that can happen in the flurry of activity, as I've already mentioned, in the conveyancing stages when completion's about to happen. So it's not always the purchasers that sign it. It's not witnessed, or So if you have a JO, then you've got a document that specifies the joint ownership and the manner in which the parties want to own it. Okay.
And for in terms of the Form A, many of you will know that as from the end of February this year, it's all going to be online now. So of course, you're having to go onto that lovely portal and do it online. So there we are.
Yeah.
Well, as you both know, Safta and Lisa, there are some really helpful online platforms available to families going through divorce and separation.
Yes, we do.
Absolutely.
That's a nice segue. Look, we're caught up with all our live questions for the first. Oh no, just as I was saying that. No, so it's just clarification. So not Form A, but Form A restriction.
Is there a conveyancing Form A?
But perhaps that's what it sounds like from our conveyancer.
Okay, so it looks like I think there's two, but there might be two conveyancers.
Possibly, yeah. I think it's a conveyancer.
Victoria, can I just say thank you, Victoria? You've been a great help today.
Thank you.
Can you just confirm, because you seem to be our only conveyancer, is there a Form A for conveyancers? Because in matrimonial finance, that's how you start those proceedings, with a Form A. So it's confusing.
That's right.
Victoria can tell us the answer.
Yeah, that'd be really helpful.
Clarify the Form A confusion.
Yeah,
that's right.
Well, it's really lively today.
It is, isn't it? Very good.
Whilst we wait for Victoria's response, another question has come through just now. In which situations will the unmarried partners' restrictions will they be successful?
Oh, ask the land registry.
Yeah, exactly.
Yeah.
Okay.
Yeah.
Yeah. So, okay, if you're happy with that's the answer.
Right, the SEV one. Yeah, that's right.
Okay, so it looks like So it looks like there's a Form A. It's A for SEV, but called Form A restriction.
Okay.
Right.
Yeah. I would have thought an SEV is a severance.
That's right. That's the SEV.
Can I just say, severance is not the same as putting a restriction on. But if you sever the joint tenancy, usually, if you don't say anything in the severance, you have created a tenancy in common in equal shares. The next stage, once you have done it, is to register it on the title, so that the form of words under the charges register, part of the title, it tells you, it gives an indication that the beneficial interest has been severed, the tenancy, the joint tenancy has been severed.
And our conveyancer says you need a separate RX1 form. The severance form is
that how you do it with an RX1? As well as, so it's the same, right? So it's the same form to register the severance as you use to register the restriction to notify purchasers. That's interesting because
that's interesting.
I'll tell you why that's interesting, and I think Saf's just going to say the same as me, that in one situation you are severing the joint tenancy. Yeah. In another, you want an RX1 restriction because the property is solely owned.
That's right.
Isn't it?
That's right.
And you want to notify purchasers, hello, I'm the non-owning party. I don't want you to buy it unless I'm going to get my net sale proceeds, my share.
Yeah, that's right. Lisa, I know you mentioned the charges register, but it's in the proproprietorship.
Sorry,
don't worry. And I think somebody's corrected us on that.
Just put that on there.
Not a problem.
No, but interestingly, I would say that I see it in the charges register because it's usually it's not in the proprietorship register. It's usually under the charge to the mortgagee.
That's right. I've seen it there as well. Exactly.
That's where I see it mostly.
And you know what's really interesting? We're not even conveyancers, are we? And yet we come across a lot of this, don't we? So
Well, it's obviously touched an interesting point for a lot of people, and I think the clarification on this is very welcome, because it seems to be an area of confusion and unclarity. So I'm hoping we've sort of unmangled that knot that some people had on this topic. We still do have 15 minutes left. So if you have more questions on this or anything else, please do pop them in. I think we are now at the stage, I said this earlier, we are now at the stage of going through all these live questions that I think we're up to date on. So if no one has, if they've just had a couple of comments saying that's very helpful, so thank you.
That's the one. Thank you, Victoria. Victoria's put the wording.
Yes.
Yeah.
So the restriction: no disposition by a sole proprietor of the registered estate except a trust corporation under which capital money arises is to be registered unless authorised by an order of the court.
Thank you very much. That's the wording.
Extremely helpful. Thank you. Perhaps we can add that to the follow-up of this to those.
Perhaps we can add Victoria to our speakers.
Yeah, she might be needed for the specialist. Yeah, just a couple of people who've messaged say thank you, because that's been very helpful.
Good.
Good. If there's no other live questions, we'll pop into the first of our pre-submitted questions, of which we've had many. So, how I pick one, I don't know. I'm just going to go for the first one for the sake of starting somewhere. So that question is, unless there's no other live questions, just checking once more time. No, I think we're good. Why do people sometimes pursue a nullity of marriage order as opposed to a divorce?
Okay, so I'll answer this one then. So nullity, of course, then is where you're then seeking an order. We used to call it a decree, but as you know, those terms are gone now, aren't they? Because we're not supposed to be saying decree of nullity, decree of divorce anymore. So, but basically, it's a nullity of marriage order, which essentially is where you're asking the judge to declare that this marriage either is void or voidable. So it's either void ab initio, i.e. from the outset, or if it can remain, and if it was to remain, it therefore becomes voidable, and therefore you're taking that plunge, you're taking that opportunity to say, actually, I want this to now be regarded as null and void. The question is, why do people go for nullity as opposed to divorce? Well, one, because with a divorce, we've still got, even though we've had the changes that came in 6th of April last year, we've still got the 12-month rule. So you've still got the MCA Section 3.1. You cannot commence divorce proceedings for the first 12 months. Nullity you can. So sometimes people may feel that that's a need for it. But secondly, and significantly, why people tend to go for nullity, and it's not very common, but sometimes, and as some of you will know, there's specific grounds under Section 11 and Section 12 of MCA, but sometimes it may be because people have maybe a religious or maybe a cultural objection to divorce. As you can imagine, divorce, what it is, what it stands for, the stigma of it, sadly, across all cultures is massive. But with nullity, there is the argument that ultimately you walk away by saying, actually, I wasn't even married to this person. And sometimes that does help just to be able to, go through their life. So it still definitely has a place in the law.
Yeah, I agree with that, because I think certainly I remember dealing with a lot of people, a lot of women in Leicester, where there is a high preponderance of Asian ladies, and the marriages are arranged, they don't always work out, and I remember doing a spate of nullity cases in court, which obviously require quite a degree of sensitivity, and it's clear that these very young women who have been engaged in an arranged marriage that hasn't worked out, their families obviously want to make sure they're not seen as sort of tainted goods, because unfortunately that is the view culturally if there were to be a divorce. But if there's a nullity, it sort of wipes the slate clean, enabling them to get married again.
Absolutely. And the good thing about nullity, just like if you decide to go for nullity order, you're still permitted to bring your financial order claim, so you can still do that.
Yeah, exactly.
And that's where some of you will be aware of that Akhtar and Khan case, which is a very significant one, where they only had their religious marriage here in England, not their civil, and some 18 years later, wife sought to divorce, only to be told by the Court of Appeal, well, actually, we're not going to recognise you weren't married. And sadly, that's where there is abuse that goes on, and this is where sometimes the one party may abuse the other vulnerable person in those situations by simply not inviting them to enter into a civil marriage. And it's really unfortunate, that case, because even though at first instance a judge said, look, I'm going to declare this as a void marriage, and hence
jumped through hoops, didn't he, to try and get her.
Absolutely. And yet, unfortunately, the Court of Appeal took the other way. And it's one where we may see a change on that in the future, but the law is as it is.
But I think we really need to emphasise that, and it's unfortunately we only get these cases when everything's gone wrong.
Exactly.
There needs to be much more publicity out there, I think, amongst religious communities whose marriages are not necessarily recognised under English law, that, you know, when you are conducting marriages, before you get to that point, before you conduct the religious marriage, please advise the parties to have a civil wedding.
Exactly. That's
so
right.
Important.
So important.
Yeah.
Excellent. Thank you both. That's extremely helpful. We've still got about 10 minutes left or so. So if anyone listening does have any questions they'd like to ask Alyssa and Safta, please do pop them in the chat or the Q&A. But we'll go back to our pre-submitted questions. So next pre-submitted question is this: Is the concept of common law wife relevant at all in LAW 1999 disputes?
Oh my gosh! Oh, I feel like I want to go and bang my head against the wall when I hear this one. I'm going to say something really politically incorrect. I have, if any of you have ever been at any of my lectures over the last 30 odd years, you might have heard me say there is no such thing as the common law wife, and it's very tempting to say you may be common, darling, but you're certainly not a wife. No, there is no such concept. I don't know where it comes from. It might come from Scottish law. I don't know what it is, but they're not wives. There is no such concept in English law right now or in the last 50 years or 100 years. It hasn't existed. It doesn't exist. It's nothing.
Absolutely. Having said, you're absolutely right. Having said that, if of course,
careful, Safta, careful.
Yeah, no. if let's say you've got a client who comes to see you and says, look, I lived with this bloke for the last 30 years and I believed that I was his common law wife, and now, Alyssa, you're telling me, it doesn't exist. Well, all that money I then spent on the house and everything I did, where do I stand with that? But what it can do...
Poor old Mrs. Burns, who wasn't
absolutely
Mrs. Burns.
Absolutely. But what it can do is it can go back to what we were saying earlier, intention. You can say, well, actually, I thought, I was married to this bloke or this lady. And
well,
therefore...
possibly it's about the assurances.
Exactly.
Possibly. And it's about detrimental reliance.
Absolutely.
And all of that. So possibly you might not have a Talata constructive trust type case, but you might be able to argue a estoppel. Exactly. You might.
That's right.
So what in those situations, maybe I'm naive to this, but was it Mick Jagger or someone who got married in a different country and the laws...
Yeah, I think it...
And they, 40 years later, when they decided to divorce, they never married in the first...
They weren't married. They weren't married. Mick Jagger and Jerry Hall. They weren't actually married.
Yeah.
Which presumably is why she then went to Richard... what's his name? Rupert.
Yeah.
Who's about to do it again for the 5th time.
Is that right? Okay, well, I think we could be any clearer on that one. So that's very 2 minutes. I've probably got time for one more. Just checking no one has got one that they've asked. Otherwise, we'll go to another pre-submit. No, I think we're all good. Okay, so the next one here. I think you've probably answered this one because it's in relation to nullity again. So here we go. What is the effect of the Marriage and Civil Partnership Act of 2022? That's the newest one, right?
Yeah, that's right. So that came in fact, just over a month ago, 27th of February. So that came in. And what it's done is basically increase the minimum age to enter into a marriage or civil partnership from 16 to 18. Okay. Number of reasons why it came in. Principally, it was to have an impact on the type of cases where you may well get forced marriage cases, particularly for 16 or 17-year-olds. But also there's an argument that by increasing the age, there is an argument that one may well be more mature and therefore be able to take on those responsibilities in a different way. The other thing to bear in mind with that is when I've dealt with, for example, forced marriage protection order cases, obviously, when you're dealing with those matters, you'll have sometimes children, 16, 17-year-olds, who one party may say, look, they consented, the other party may say when they were forced. But of course, now it's not possible for them to consent, unless they are 18. So even if the respondents were to try and argue that, clearly this act would say otherwise. So it's come in, and hence it's changed, obviously, the Marriage Act, it's changed the Civil Partnership Act, coincidentally as well.
And I think it's a good thing, actually, to safeguard under 18s. I really do.
I'm glad I'm not going to ask this question because it's at the end. But I mean, I would have been interested to hear your thoughts on what's been announced in terms of the mediation potential mandate of mediation. But with the 5 minutes we've got left, I think it's safe. We best save that for another time. I think that the answer to that might be longer than the few minutes we've got left. Changes are afoot, I suppose, is the conclusion that we can come to. Right, well, thank you, everyone. Unfortunately, that is all we've got time for today. What a brilliant one it was, though. Thank you for all your engagement and involved. It's really made it dynamic and interesting for the three of us. So we're very grateful. Thank you to the solicitors group and Family Law Shape the Debate, and hosted by our Family Wizard. Thank you, of course, to Alyssa and Safta for the expert contribution and speaking. Don't forget to join the solicitors group LAW2023 Online community on LinkedIn to continue the debate after the live session and to be included in exclusive offers for future events. As I mentioned at the beginning, a recording of today's session will be sent out by email within the next few days. There's still time to watch the pre-recorded content as well. Your expiry date will be displayed next to the webinar. And there's still time to buy the complete event, including a recording of this session, if you haven't already. To book, just go to www.thesolicitorsgroup.co.uk, where you will also find the online exhibition. The exhibition is open for anyone to visit, and if you have booked the entire event, you can claim your free 1-hour CPD webinar from the Webinar Learning Catalogue, which is worth £35 plus VAT. You can also visit our exhibitor page to find out more about Our Family Wizard. If you do want to find out more about Our Family Wizard, you can find us on LinkedIn, social media, go to ourfamilywizard.co.uk, or you can email me at jevans@ourfamilywizard.co.uk. We're always happy to help and give you more information where we can. Finally, feedback forms for the event will be sent out when the event closes, and by completing this, you will receive your CPD certificate. Thank you again, Alyssa, Safta. I'm sure we'll see each other at something else very soon. That was really
James,
great.
Can I just say a big thank you to all our participants today?
Absolutely.
Yeah, absolutely.
It was one of the most amazing,
It was good.
lively debates.
Very good.
I mean, they're always lively, but
yeah.
today it was really special. So
Very good, absolutely. Kept us going.
We've been doing this for a few years, the three of us, and I think this has probably been the most engaging one that we've had. And it's been brilliant. It's been absolutely brilliant.
Absolutely.
Alyssa and Safta, there's lots of people messaging on the chat saying thank you. It's been really helpful, really useful, and breathe. And someone asking for more of this. So it's really helpful. Right, we'll call it there. Thank you, everyone. See you very soon. Lovely afternoon.
All the best. Take care. Bye then.
Bye.
Bye, everybody.